Well, thank you. And good afternoon to everybody. It's a pleasure to be with you and a privilege. And I hope you can see that I'm wearing the badge as honorary member of the Ukrainian Association of Family Mediators, thanks to Tanya. Carly and I are going to talk about domestic abuse and mediation. And I'm going to start by talking about the very high rates of domestic abuse, which I'm sure we are all aware of, but they are shockingly high. In the UK, an incident of domestic abuse is reported to the police every 30 seconds. In many cases, alcohol or substance abuse is a factor, but it's estimated that less than 24% of domestic abuse incidents are reported to the police. 1 in 4 women, 1 in 4 experience abuse, mostly from their partner or ex-partner, and 1 in 6 or 7 men. And 1 in 5 teenage girls say that they experience domestic abuse in a dating relationship. The next slide, please, Viola. Thank you. The Domestic Abuse Act 2021 in England and Wales defines behaviour as abusive if it involves any of the following: physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological or emotional abuse. And abuse may consist of a single incident or a pattern of conduct. Next slide, please. Yeah, a research study in Australia on experience of abuse found that the majority of respondents said they had experienced verbal, psychological, and emotional abuse daily, and this has made a more devastating and longer-lasting impact on them than the physical attacks. In the UK, are we on the right slide? No, I think, could we go to slide 5? Slide number 5, about Australia. Yes, that's it. Yeah, that's it, even though I can't read it. In the UK, Rosie Duffield MP gave a moving speech to the House of Commons in October 2019 about her own experience of coercive control by her partner, and she received a standing ovation from her fellow MPs. Next slide, please, Viola. So that somebody hasn't got audio. Right, I hope people can hear. The next slide, please.
Viss ir dzirdams, paldies.
Could I have the next slide? That's it. Different forms of domestic abuse carry different levels of risk. In some cases, partners insult each other, throw things, but don't cause injury. But children may witness these scenes and may be very distressed and afraid. In some cases, abuse occurs for the first time when one partner tells the other that they want a separation, and the rejected partner may react with a slap or throw something that is not characteristic of their relationship. And this may be a one-off incident, and it should be distinguished from repeated assaults by one partner on the other, which carry far higher risks. The next slide, please. Thank you. Domestic abuse has profound implications for children. Where there is domestic abuse, it's really important to look for child abuse. 1 in 5 children have lived with a perpetrator of domestic abuse. 62% of these children suffered abuse directly, as well as the harm caused by witnessing or overhearing domestic abuse against maybe their other parent or another child. And witnessing or overhearing domestic abuse in English law is a form of child abuse. The next slide, please. There is a shortage of places in women's refuges in England for women who try to escape with their children from an abusive partner. In January this year, our government allocated £2 million to enable a victim of domestic abuse without financial support to find a place in a refuge or rented accommodation with a payment of up to £500 or, if necessary, up to £2,500 to prevent homelessness or returning to the abuser. And this is like a piece of sticking plaster, which gives a chance of security, but it doesn't heal the harm done to women and children, mostly women and children. Next slide, please. Is that slide number 9? Because I don't know. Is that number 9? Yes, I think it is. Yeah. Is it? Anyway, separation doesn't end abuse, and it may even heighten the risks for the mother, usually the mother, and the children. The abandoned parent, usually the father, may apply to the court for a child contact order or residence order, and the order may be made by the court. If both parents haven't already attended what we call a mediation information and assessment meeting, MIAM, within the previous 3 months, the court has power to direct them to attend separate meetings with an accredited family mediator. The court does not have the power to order mediation because it's voluntary, and both participants must be willing to take part without any pressure and in a way that's safe and acceptable to them. Next slide, please. Prior to making the application concerning children or financial matters in private law proceedings, our law requires applicants to attend this initial separate information assessment meeting with an accredited and nationally registered family mediator. But some people find ways to avoid it. And there are also categories of exemption, such as evidence of abuse from the police or a social worker or a doctor. The other party is invited, but not required, to attend a separate initial information and assessment meeting. And at each meeting, the mediator seeks to discover through a screening procedure whether or not there is any fear of abuse or any other harm, or whether it's alleged that any participant or other person has been or is likely to be abusive towards another or towards a child. This comes from our National Code of Practice for Mediators. Next slide, please. And when we undertake this initial information and assessment meeting, the mediator needs to show empathy and build rapport with each individual who may be extremely anxious and distressed. The mediator needs to understand their situation, the urgency, and their needs, explain mediation and other ways forward, and assess the suitability of mediation and their willingness, and whether it's suitable. And these questions need to be asked in the course of a friendly conversation, not as an interrogation. And we need to use, I think, carefully graded questions that start with low-key, broad questions that don't alarm people, just everyday kind of questions, like did you argue much before you separated? And move up the scale with more detailed questions about the exact nature of any abuse experienced or feared, the frequency of its occurrence, and using a detailed questionnaire, which I think Tanya may have mentioned too, noting the response to each question so that we can assess each person's need for help and support and help them plan the way forward, which may or may not be mediation. I think one of the problems we need to recognise is that the title of family mediator doesn't have protected status in the UK and maybe not in other countries either, like a doctor or lawyer. But the problem is that anybody actually can hold themselves out as a mediator. And as a result, there are risks that couples may go to somebody who calls themselves a mediator, but is not actually trained or accredited. And then there may be negative reports of their experience because they went to somebody who was not properly trained and accredited. And we need to address this problem. Certainly, it's essential that, as far as possible, the general public is aware that they need to look for an accredited mediator and go online to our national register and find a mediator in their area who is, or online, who is actually accredited and fully trained. If we're now on slide 12, yes, mediation, I think we can say, isn't suitable if it takes the form of a joint meeting where there has been or may be abuse or major power imbalance or fear. A joint meeting puts at least one participant under added stress, and they may capitulate and compromise in a way that's really causes long-term disadvantage and consequences for them. So this is not the way to conduct a mediation. And even if control is maintained during the meeting, there are risks that one may follow the other one as they leave the building and even assault them afterwards. So this should be avoided. Thank you. I think the next slide, please. When mediation is found unsuitable at the initial meeting, the mediator signs a form for the court. An accredited mediator can sign a form. It has to be an accredited mediator, stating that the individual has attended an initial information meeting and mediation was found unsuitable, or that the participant didn't wish to take part. But we don't give any details on the form. And an application can then be made for a court order on child-related issues or other matters. Where there are indications that a child is in need of safeguarding, the mediator must make an immediate referral to a child protection agency for further inquiry and protection if needed, if necessary, taking the child into care. Next slide, please. And many separating and divorcing couples believe that a court order will resolve matters. But they may be mistaken. Litigation can take a long time and go on for years. And does the court provide safety for adults who've experienced abuse and who may be at risk of further abuse, and for children who may be at risk? The short answer is no. The court does not provide protection. A person who has experienced abuse may find that they're seated in court very close to their abuser, which puts them under further stress and re-traumatizes them, and may be followed afterwards and assaulted after they leave. And studies show that court orders may even increase risks of adults and children being subjected to continuing abuse. The next slide, please. I think it's 15. That's right. This is 15. Yeah, thank you. When the resident parent, more often the mother, withholds the child's contact with the father, stating that the father is abusive and that the child is refusing contact, some fathers retaliate with counter allegations of parental alienation. This probably happens in other countries and not only in the UK. Parental alienation attributes, in theory, the child's rejection of a parent to the deliberate or unconscious influence and actions by the resident parent to turn the child against the other parent. And the child may be caught in a kind of toxic triangle in which the mother alleges domestic abuse and the father alleges parental alienation. But in a large study, which I'm not quoting here in detail, but there was a large study with young adults who had experienced their parent separation as children. They were asked about what had helped them and what had been difficult. And they said that when they no longer had contact with their other parent, they said it was not because the parent they lived with tried to prevent them and turn them against the other parent. They had their own reasons and they wanted to be listened to and to explain their own reasons. So next slide, please. Abusive men and women come from all social backgrounds and all personality groups, from loud and aggressive to mild and passive, and it can be difficult to distinguish those who pose a risk to their partners and children from those who do not. Lawyers, including judges, may underrate the degree of risk posed by men who manage to portray themselves as the better parent and exploit shortcomings in the mother's parenting. By referring to mental health issues which the father gives as evidence of the mother's unfitness to care for the child. And if no one listens to the child and the child's words are disregarded, the court may make an order that actually allows abuse to continue. And we do, I'm afraid, have evidence of this. The next slide, please. In 2020, our Ministry of Justice published its final report on assessing risk of harm to children and parents in private law children cases, which is known as the harm report. This is really a very disturbing report. It criticises the adversarial system in law, which treats parents as opponents in unequal battles over their children, often in prolonged litigation. And the report identified that the family courts have a pro-contact culture in which they prioritise the child's contact with a non-resident parent and overlook or dismiss allegations of abuse and what the child says, thus putting children at further risk. Thank you. Next slide, please. When a parent seeking contact accuses the resident parent of causing parental alienation, the court generally appoints a child expert to inquire and report to the court with recommendations on the best interests of the child. And the courts here have been criticised for using sometimes unregulated child experts who may not speak with the child or who fail to take account of the child's concerns and objections. There's been a recent study just published actually a week ago in the Journal of Family Trauma, Child Custody and Child Development. I can provide the link, the full details, of a study in Manchester that studied 45 cases in which the woman alleged abuse. And they're really quite worrying cases, which shows that the court does not provide adequate protection and that children are not listened to carefully enough. When young people are asked about their experience, they say that what really matters is the quality of their relationship with both parents before the separation. If they have a good relationship with, generally it's the father, but it may be the mother, before they leave the family home, then their contact is much more likely to continue and both the child and the parent want it to continue. And if the parents manage the separation and are cooperative with or without mediation, then it's likely to continue with benefits for all concerned, including certainly the children. But if children are forced against their will, without being heard, without being listened to carefully, there can be actually long-term harm to the children if they're forced into contact against their will in a situation that may be damaging. And we need to listen to them more carefully, but it needs to be a child consultant or mediator who has sufficient additional training. And this again is another real priority. Thank you. And next slide, please. So I've just referred to this study in a study, it was a case reported in last December, in which a family court judge accepted the finding of an unregulated child expert that the mother had made entirely false allegations against the child's father, and the judge ruled that the child, who was a girl of secondary school age, should be removed from the mother's care and transferred to the father against the girl's wishes. And the judge also ordered that this unregulated child expert, who described herself as a psychotherapist, should undertake a program of therapeutic work with the girl. So the girl was forced to comply with this order, and her actual objections and fears were dismissed. So there have been other disturbing cases. I don't know whether similar research has been done in other countries, but next slide, please, Viola. There have been other disturbing cases, some reported in the press or in case reports, in which children have been, sorry, the next slide, could we have? Thank you. In which children were transferred to their father against their wishes and ran away, and were eventually allowed to return to live with their mother. And then I mentioned this study with 45 women who talk about the impact on them of court proceedings and how the court proceedings, they say, caused illness or trauma, and that it had a really severe effect on their health, and they experienced the court proceedings as biased against them. And we could go on to the next slide, please. The harm report, which I mentioned, found that one consequence of not listening effectively to the child is that the reasons for the child not wanting to have contact with the abuser are not properly understood or taken into account. And listening more carefully to the child may result in a better understanding whether or not allegations of parental alienation actually have any grounds or not. Next slide, please. Thank you. So if joint mediation meetings are likely to be unsuitable, certainly in cases of domestic abuse, and if the courts do not provide protection, in fact, may increase risks, clearly we need to have a process that helps separated parents, particularly, to work out arrangements for their children in the child's best interest, safely, and which gives children the opportunity to talk freely and safely with a professional they feel able to trust. And just before I hand over to Carly, I'd just like to emphasize that parents and professionals need information. They need information about where they can seek help. A recent report showed that children mostly didn't know that they had a right to be consulted when decisions are made that concern them. They weren't aware of that. And if they needed help, they didn't know where to turn. They didn't know where to turn And if there were court proceedings, they were very afraid of getting into trouble and being blamed for the court's decision. So they found it very difficult to speak to somebody who was going to write a report for the court. Whereas when they took part in mediation with a specially qualified child mediator, the independent research has reported that children and parents were overwhelmingly satisfied and reported very positively, children saying it helped them to feel better, it showed benefits to their mental health, and for parents, it was like a light bulb moment when they listened to their children, understood their children's concerns, and very often stopped arguing and agreed to the child's suggestion for a change in the schedule instead of arguing about whether it should be Wednesday or Thursday or Saturdays or Sundays. The children made a proposal. They weren't given responsibility, but they made suggestions. And the parents listened. And when they listened and discussed them, very often they said, yes, that sounds sensible. Let's try that. So there is a way forward, but it needs more information for parents, professionals, and mediators, and lawyers, and judges. We need to work at it. And I hope by working together in different countries and sharing research as we're doing here, and practice and experience, we can move forward. So I'm going to hand over to Carly now, who's going to talk about online mediation. And after Carly's spoken, if there's time, we can answer a few questions if we can. Thank you very much.